What's up, EWPPG? How are y'all doing? EWPPG and more. Welcome back to another episode of Keeping It Real with your girl, PhyllyPhyl, where you can get all the latest information on the Sweetie Pies family saga, drama, whatever you want to call it. All right, here's the latest on Tim Norman. The other day, I told you guys about his new attorneys filing paperwork to have witnesses' names unsealed and other things. Well, this was filed on 1/26. The government's response to defendant Norman's motion for disclosure of information pursuant to Brady and Giglio and defendant's motion for early production of Gents Act material, document 117. Comes now the plaintiff, United States of America, by and through its counsel, Saylor. Looks here, and they list all those names. I'm not going to go over that. Let's go on down to number, what is this one? Norman's request for Brady and the Giglio material, to the extent it may exist, is premature, as the case is not yet set for trial and should be denied without a hearing. Okay? It is axiomatic that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. And they cite the case, okay? Reliability of a given witness may well be determinative of guilt or innocence. Non-disclosure of evidence affecting credibility falls within this general rule. So, in this, it says here, in the typical case where a defendant makes only a general request for exculpatory material, and they cite the case, it is the prosecuting entity that decides which information must be disclosed. So Tim's attorney and Tim, they're wanting information. They're wanting to know all the witnesses. They're wanting things disclosed, and looks like it's being denied. It says, unless the defense counsel becomes aware that other exculpatory evidence was withheld and brings it to the court's attention, the prosecutor's decision on disclosure is final. So the prosecutor decision to release this information is final, and Tim's request is being denied. The government is aware of its obligation to disclose, the exculpatory and impeaching information in compliance with Brady. To the extent, however, that Norman asserts he is entitled to immediate disclosure of the same, he is in error. Tim, you are wrong. You're wrong. Under the rule in our circuit, Brady does not require pre-trial disclosure, and due process is satisfied if the information is furnished before it is too late for the defendant to use it at trial. There's not been a trial date set yet, okay? And it says, and it tells you what cases you can cite, and you guys can look at this and go pull these up if you like. The 8th Circuit Court has held that Brady is only violated if evidence is discovered after the trial of information which had been known to the prosecution but unknown to the defense. Emphasis added. In fact, the United States Court of Appeals for the 8th Circuit has declined to find Brady violations where the government made disclosures as little as 1 day prior to trial. So as long as they give him the information and release things before the trial, there's nothing being done wrong to the defendant. The government disclosed the FBI investigation report the day before trial, so appellants had the information in time to use it at trial. And they're talking about this case here, States versus Hepner. Just giving you what they're doing. They're citing cases that will help them to show that what they're doing in this case, the United States versus Norman, is okay. Okay, that's what they're doing. In the instant case, the court has yet not scheduled a trial date. There's no trial date scheduled for Tim yet. They go back to court in March, but that's a hearing. It says it will not do so until the completion of pretrial matters, for which a scheduling order has yet to be set. Okay? Given the complexity of the instant case, yes, it may be many months before the matter is tried. In the absence of a trial date, the government submits that it is under no current obligation to disclose Brady and or Giglio material. In point of fact, the government is unaware of any information that could be reasonably interpreted as exculpatory as to Norman. As a result, the government would have nothing to disclose, even if it were obligated to do so at this time, which, as discussed above, is not. Wow. So let's go on here. As to the Giglio material, the government has not yet begun to consider what witnesses it might call at trial. They're wanting to know the names of all their witnesses. You know, they want to know all the witnesses. And I don't think Tim needs to know the name of all these witnesses. It could be family members. We don't know who has decided to talk against Tim. We just don't know. It could be former girlfriends. We don't know what they know or what he said in the heat of the moment, in the bedroom. We don't know what Tim has released. All of those women he's dated in Cali and everywhere, they could all be witnesses. We just don't know. Even assuming arguendo that the government had developed its witness list in a non-capital case, an accused has no constitutional right to require the production of the names and addresses of possible witnesses. They want the names and addresses. Honey, you can't give Kim Norman that information. Are you crazy? As a result, the government declines at this time to provide Norman with a list or any information related to it as yet unknown trial witnesses or potential witnesses. For all these reasons, Norman's motion should be denied without a hearing. Yes, indeed. And here, number 2, Norman's request regarding the government's use of informants, cooperating individuals, and early gents material should be denied without hearing. Wow. And it just goes on here. In any criminal prosecution brought by the United States, no statement or report in the possession of the United States, which was made by a government witness or prospective government witness other than the defendant, shall be the subject of subpoena, discovery, or inspection until said witness has testified on direct examination in the trial of the case. After a witness called by the United States has testified on direct examination, the court shall, on motion of the defendant, order the United States to produce any statement. Wow. They're just listing their reasons as to why Tim's request will be denied. Okay, and it just goes on to say the language in that Gents Act imposes upon the government the obligations to produce a statement or report made by a government witness only after the witness or witnesses or whatever called by the United States has testified on direct examination. So pretty much, Tim, you can't have the list of witnesses, their names, and their addresses. It says here there simply is no support for any claim that this act requires more. Specifically, the 8th Circuit has held repeatedly that although in many cases the government freely discloses material in advance of trial, contrary to defendant's suggestion, the government may not be required to do so. And they cite the cases here. Okay, you can see that and you can look those up. Clearly, these cases stand firm for the proposition that the government simply cannot be compelled to disclose material in advance of the time prescribed, yes, by the act itself. Furthermore, in keeping with the tradition of the U.S. Attorney's Office for the Eastern District of Missouri, Gents material can be provided 1 or 2 weeks ahead of trial in exchange for a list of the defense witnesses and defense exhibits. Otherwise, material can be provided the Friday before trial commences. So guys, Tim pretty much was trying to get all of the witnesses, their names, address, and everything right now. But the prosecution does not have to play all their cards right now. They don't have to show it all. And they're citing everything that backs them up. It says here the court has previously denied the disclosure of witnesses, identities, and early material in cases as in the present case where the allegations have involved murder and witnesses. Safety was paramount. And I do believe safety for these witnesses is definitely paramount. In adopting this court's report and recommendations, the district court held that court is without authority to order disclosures of Gents Act material earlier than provided in the act, and they cite that, okay? Wow. My. Defendant Norman does not offer any additional evidence or argument in support of the immediate release of the identities of witnesses or Gents material. As such, his motion should be denied. And then they give you the conclusion. For the foregoing reasons, the government respectfully requests that defendant Norman's motion for disclosure of Brady information and motion for early Jinx material be denied without a hearing. So we'll see. There you have it, guys. There you have it. Tim's request looks like the prosecution has come back and given all the reasons it should be denied. He doesn't need to have all of this information right now. And guys, also, the government also filed government's motion to file under seal. This was filed on January 29th. Comes now the United States of America by and through, there you go, State's Attorney for the Eastern District. And it just says the government has no objection to the unsealing of their report on the sealing and its attached exhibit if the court believes the unsealing of these previously sealed documents is appropriate. I hereby certify that on 129, the foregoing was filed. That's just showing you that the government, their motion to file under seal, they filed this on the 29th. Just, housekeeping things. This was on document number 110, which, rest in peace.
It's been a long, long time, honey, but I know, True story. Everybody ain't your friend, everybody ain't your partner. I say I got you. Well, just hold it down and keep it solid. And when you're not around, I protect your name, I won't talk about you. Everybody ain't your friend.